Okay, ladies and gentlemen, if I could start out by having you applaud our volunteers. I tell my students every day that bravery is commendable. It's not always easy. It's the hard way, but it's the right way. So if you're sitting there and you're thinking, oh, I should have gotten up there and taken my chance to be brave, it's okay, because we have a second mock trial after this one. So you have plenty of time to stand up. This first case has to do with cyberbullying. Cyberbullying is an issue that I'm sure is not unfamiliar to us, whether your own children have been involved or whether you as a teenager or youth have been involved or you've seen other people involved with it. It's kind of a part of our world now. And so talking about not only the kind of people we want to be, is that something I want to personally do, but also the potential legal ramifications around this issue of cyberbullying is what we're focused on right now. So we've got a bailiff. Everybody give it up for the bailiff. We've got a defendant. So you're the plaintiff's parent, and you're the defendant's parent. I might have told you the wrong thing. So you're the defendant, plaintiff. Judge! County attorney. Now, she's just here to answer our questions. So, go ahead and give your attention. When we get done with the case, we'll have an opportunity to hear some knowledge about the subject and then to ask some questions if you have specific scenarios that you'd like to know more about.
After receiving numerous text messages and Facebook posts from a fellow student, a high school freshman sues his classmate for intentional infliction of emotional distress. We will now hear the case of Boop versus Veep. Veep has been accused of intentional infliction of emotional distress. The defendant is countersuing for cyber harassment.
Yep, I got it. Okay, bailiff, have all the parties been sworn?
Yes.
Okay. All right, this is the time and place set aside for the hearing of the case of Boop versus Veep. Before we get started, I want to just kind of give a little overview of what we're talking about here. In the Iowa court system, we usually have two types of cases. We have a civil case and a criminal case. This particular case we're going to be hearing in a few minutes here is classified as a civil case. Basically, the difference between those two, in a civil case, the remedy or the relief provided by the court is typically a money judgment. In a criminal case, there's typically a jail term and or a fine, or just a fine by itself. So that's kind of the difference between the two. It gets more complicated than that as we get into it, but I'm not going to go through all that. One of the things that changes is the burden of proof changes in a civil case versus a criminal case. So with that, we'll go ahead and get started. Mr. Boop, this is your case. Are you prepared to proceed? Yes. You may call your first witness.
Starting on October 12, 2016, Veep and I became friends on Facebook. We didn't really talk much at first. Then one day, she sent me a message saying that I was ugly, that everyone hated me, and that nobody would care if I were gone. At first, I ignored it. Then I blocked her from Facebook. At that point, she started sending these messages to my Instagram and Snapchat accounts. I have copies of every right here.
Okay. This is your evidence you're submitting before the court? Mr. Veep, do you have any objections to the evidence submitted by the plaintiff?
I do. I was kidding when I sent those messages. I was just trying to get a rise out of her. She knew that I was just angry that she had hurt one of my friends by dumping him. I wanted her to be sure that people knew how cruel she was to my friend. Plus, I have free speech.
Okay.
Intermission about free speech.
Okay. One of the elements in a slander or libel case, or in this case, the civil case that has been brought before the court, one of the elements is the outrageous conduct of the defendant. In a case like this, just because somebody says something about you that makes you angry, doesn't necessarily make that rise to the level of a situation where the court would award damages. The acts of the defendant have to be outrageous, they have to be intentional, and they have to show that the defendant or the plaintiff suffered a severe or extreme emotional distress. So that's kind of the bar or the level you need to get to make your case. Okay? Ms. Ellie, would you like to add anything to that?
Just that there is the right to free speech, but where it infringes on others' rights, that's when the line is drawn there. So in this case, this is a civil matter and there are money damages. However, my office deals with the criminal matters. And for a case like this, you would see something arise in my office through charges of harassment. And that counts even if it's over electronic media. It could be in-person harassment, but that's really how we get involved. And if you're going the civil route by suing somebody, it's a much harder road to hoe, because you basically have to have an attorney file the lawsuit. The people you're suing have to have a lot of money, otherwise it's not going to be worth it for you or the attorney. And this is a very high standard for intentional infliction of emotional distress. So, whereas the criminal side, harassment only needs to be conduct or communication with no legitimate purpose that is meant to annoy, alarm, harm the other person in another way. And that's how my office would get involved in this type of case.
Yeah, I think one other thing on a case like this, one of the elements that the plaintiff needs to prove is that they suffer an extreme or emotional distress as a result of the defendant's actions. And that's a pretty high standard. It's not just that what they said made you mad or hurt your feelings. You need to have something above that, okay? All right. You have a witness you're going to call, Mr. V? That's your mother?
My son first told me on October 17th that he was being cyberbullied. I called the school, but they said that I couldn't do anything about it, or they couldn't do anything about it because it was all school property. I then got onto my child's Facebook account and sent a message back to the defendant. I stated that he needed to leave my child alone. I explained that he was out of line and that there would be consequences for his actions. I have all the messages here.
Thanks, Paul. Okay. Mr. V, do you have any objections to the evidence that's been submitted? All right, now it's your turn for your dad.
My child came to me after the plaintiff's parent got involved. What kind of adult threatens a child? My child was mean and I'm embarrassed, but I believe he didn't do anything illegal. Kids say mean things all the time, and when an adult tells a child who is not their child that there will be consequences, that's just wrong.
Okay, does either side like to make a closing remark? Anything that you haven't brought forth to the court that you want to bring forth before I make my decision? Got everything in? Okay. Like I said earlier, a case like this seems to be something was said and it may have hurt somebody's feelings, but I don't think it rises to the level of any intentional conduct where the plaintiff suffered a severe or extreme emotional distress. So my finding in this case is going to be in favor of the defendant. Elliot?
Just have some comments to add. The parent was talking about sending a Facebook message to a child in response to something that the child said to their kid. In no circumstance do I recommend that. If there's cyberbullying going on, what you should do is make sure you save the messages, number one. Number 2, report those messages, and also your child should ask the bully to stop bullying them, just so that it's clear, there's no ambiguity in any way. And then 3, report it to the school, report it to the police, whoever you think might be the appropriate party. In this case, it said because it was off school property, they didn't think that the school would do anything, but I don't know that that's the hard line that the school is taking any longer. If it affects the student body and it affects the school, I believe that's something they'd like to hear about at least. They were talking about some extreme emotional distress, and that type of thing can happen from cyberbullying. You see all the time that kids get depressed on the news and maybe even have suicidal thoughts, and that's the type of situation where you're getting the extreme response to this bullying, and that's the type of effect that this type of a case, this lawsuit, is directed towards. You know, when it gets to that point where there is a potential that another child lose their life because of the bullying that's being inflicted on them, that's when you really hear about these intentional infliction of emotional distress types of cases.
Yeah, in addition to that, one of the elements I talked about earlier was the plaintiff has to make a showing that they suffered severe or extreme emotional distress, and one of the criteria of extreme or emotional distress is suicide or attempted suicide. So it has to rise above the level of just something that made you mad. Okay?
Thank you very much, volunteers. All right. So what I'm going to do at this time, because I saw sort of the eyebrow telegraph going off with some of you as I was watching you, and so I want to give us an opportunity to kind of close this subject. If you have any specific questions, you know, one of the things that was recommended was to take screenshots. You know, if you see something that you think is probably crossing a line, to take a screenshot. And so I guess I would ask the two of you, what do we do with those screenshots? So let's say we have them, let's say it's happening off of school property, what do we do with those screenshots? Who do they go to?
Are you talking screenshots of inappropriate pictures? Is that what it is?
No, I'm talking about sort of finishing this up. You know, you mentioned if there's cyberbullying going on, take screenshots
Oh, right. Save the
of
messages.
the communication. But what do you do with that? You know, if you feel like we're getting these messages again and again and again, we would like for it to stop before our child is in a dire circumstance. What do you recommend that people do with that?
Once you have those screenshots, you should definitely bring those to either the school or the authorities. Having those screenshots is good for many reasons. One, it's showing who's the aggressor. Two, it will help me if the court system does need to get involved, then we'll be able to use that to hopefully affect some change. But I find that a lot of times with kids, if you just bring it to their attention that their action is wrong and that they're hurting somebody else, it will die down. If it doesn't, that's where we come into play, and there's a juvenile court system that can handle harassment against children.
Any other questions or concerns about this issue of cyberbullying? You know, there was some mention of what schools can and can't do. We do have some administrators here if anybody would like some additional clarification on that. Any other questions, thoughts? Yeah, would you like the microphone?
No.
Okay.
I'm pretty loud.
Okay.
You know, while both parties up there mentioned that the burden of proof or the level that said abuse or bullying needs to rise to is pretty extreme, I think it's also important to note that extreme emotional distress is almost entirely subjective, and that what may cause one child emotional harm is with that?
Well,
To answer your question on the, I think you said it was subjective. Once it gets to the court, it's not subjective. We have a standard that we have from a case law. In other words, there's been other cases, either in Iowa or adjoining states or wherever there's been a case, that have kind of set the standard on what extreme emotional distress means. For instance, if your dog gets run over in front of your house by a car, you're not entitled to any monetary award for that other than the price of the dog. If you happen to be in the front yard and witness it, then by the court standards, you're entitled to emotional distress, so you can receive some money for not only the value of the dog, but how much distress it caused you. So it's not so much just purely a subjective matter. There are standards that have to be met.
I'm sorry, I wasn't clear. What I meant was that what might cause one child emotional distress might not cause another child emotional distress.
That's exactly right.
If one child seeks counseling, it may not mean that same type of harassment might cause another child.
That's true, that's true. And that's kind of why the court has the element set so high that one of the things for emotional distress is it may not be just counseling, it may have to be a little higher than that. So, like I said earlier, just because somebody says something that makes you mad, that doesn't necessarily meet the standard of emotional distress. And you're exactly correct, though. What a child especially will be bothered, one will be bothered more severely than another by a statement made about it. Somebody says something about me now, I don't care. When I was 14, it probably bothered me.
So in a case like this, a civil case, you'd likely have a jury. They can waive jury and have a judge hear the evidence. So the jury or the judge will be looking at the effect, not necessarily the conduct in a case like this. So if the conduct is something that would make one child, cry one night and get over it, the next child might have a much more profound effect on them. The jury will be looking to see if there was actually severe emotional distress, and that's the standard. And so you have a jury deciding these types of things, and so it is in a way subjective because it's up to them to decide whether the effect met that level.
Yeah, when Ms. Sully is absolutely correct, but if the jury's involved and the jury goes back to do their deliberations, the judge will read to them jury instructions. And that's one of the instructions will be in there. How do you measure emotional distress?
Thank you. Anybody else? This is a really, it's a tough issue, right? We don't want our children to be hurt. We don't want our children to say hurtful things. We don't want our children to feel unsafe. We don't want our children to feel lonely. And there is obviously a lot that can be felt and that can happen before we're getting to this kind of a level. And so, again, that's where we come back to if it's affecting the child's ability to function in school, that's when it needs to be brought into the school. So we're going to go ahead and move on to our next case. Our next case is about earmuffs kids' possession of illegal images and the sharing of those images, which is an ongoing and ever-growing issue with young people and phones. I do need a couple of volunteers. I need 2 parents and 2 teens. You do not have to come up here with your own teen. If you are a teen, you do not have to come up with your own parent, okay? So we need 2 adult volunteers and 2 child volunteers. So we're looking for 2 more. We've already got a bailiff. He is rocking out at being the bailiff. Let's hear it for the bailiff. Look at that. Look at that power stand. Okay, am I gonna have to be the other teenager and the teenager's parent? Okay, it's happening. We'll do it. Oh, good! See, Gregory is curriculum!
Okay, so this next case, as she was saying, deals with pictures, naughty pictures. To preface this, I want to say that prosecutors have what we call prosecutorial discretion. And so we decide what certain cases need to be brought, how to deal with certain matters. And in this case, there was a prosecutor in Iowa that was threatening to bring a sexual exploitation charge against a teenage girl who sent 2 photos of herself to a high school classmate. Sexting involves sending sexually explicit photographs or messages via cell phone or other mobile devices. Her classmate is facing charges for sharing those photos via text message and several other students from the high school. This is a sexual exploitation charge. There are other charges that can be brought if there's cases where there's dissemination of pictures of children not dressed, possession of child pornography, dissemination of child pornography. And in this case, even though these are pictures of this high school girl, and she took them, if she's taking these pictures and she's sending them, she can be charged. Now, that's where one would use prosecutorial immunity to see really, I would look at whether or not it was malicious when you're sharing these pictures. If the young student who sent these pictures on, forwarded those pictures on, if that was for any malicious purpose, that's really when I think that I might decide charges need to be brought.
Before we get started here, I'd like to talk a little bit about what the charges represent in this type of a situation. There are 3 levels of sexual exploitation of a minor. The first level is a Class C felony, which carries up to a penalty of up to 10 years in penitentiary. The second level is a Class D felony, which carries up to 5 years. And the third level is an aggravated misdemeanor, which carries up to 2 years. So you've got 3 different levels depending on the elements of the charge. So with that, Kellen, go ahead.
We will now hear the case of DA versus Vix. Vix has been charged with sexual exploitation.
Okay. This is your turn.
I sent 2 pictures to a guy I was talking to on Snapchat. It's my body, so I don't see why it's a big deal. Plus, those pictures disappear right away, and you can tell when somebody takes a screenshot. He did, and I got a notification. It became a big deal when he sent it to all of his friends. I don't think I should be in trouble, but I think he should.
Sorry, go ahead and pick up on your page. Yeah.
I did not ask her to send those photos, but when she did, wasn't she giving me permission to share them? Also, everyone in our school is doing it. I think if a person sends me something, it's mine to use and share. If she didn't want her nudes out there, then maybe she shouldn't have sent them.
And I'm out of place here. We got the parent of the female student. Is that you?
Obviously, my daughter had an error of judgment. I'm not questioning that, but I do think this error should follow her for the rest of her life. Absolutely not. My daughter is a caring and wonderful individual. If she is forced to register as a sex offender, it will ruin her life. How does having her register as a sex offender help us to keep our communities safe? This is a personal matter that requires their parenting skills, not courtroom intervention.
Who's the parent?
This is crazy. Teenagers make poor choices. My son isn't a criminal. He's not a pedophile. He's definitely not preying on children.
Okay, Ms. Elliott, as prosecutor, do you want to offer the closing remarks, please?
Hello. Ordinarily, in a criminal case, the plaintiff is the state. So I would represent the victim in the state of Iowa, just as in general. In a case like this, I might argue, this does have a profound effect on a victim in this case. These photos will follow her for the rest of her life. Whether they know it or not, it's out there on the web. Anybody can have these pictures. And so when mom says, I don't think that this should follow her for the rest of her life, well, maybe a criminal conviction won't, but those pictures will be out there. And who knows who's getting their hands on those things. So, I would also argue that in no case does a picture that is sent to you become your property and you can do whatever you want with it, disseminate it to other people. We recommend that if you receive any of those photos, you immediately report those things. We don't want any of those things getting out any further than where it ended up on your phone. Let me just check my notes real quick. We also talked about, this also brings up the issues of if you're taking the photograph and it's getting out there, what sorts of social backlash will there be? What sort of job prospects will you lose out on because there are these pictures of you out there? As the sharer of these pictures, you can be charged with the dissemination of child pornography, and those don't carry light sentences. You can be charged federally, and that's even stricter. There are severe consequences when you are dealing with these photographs, especially of children, young children. Under the age of 18, you're still a child. So any pictures that are taken of a person under the age of 18, even if that person is no longer 18, if the picture was taken when they were underage, it will still be illicit material and you can be charged for possession of child pornography or dissemination of child pornography. This case was a sexual exploitation case, and I don't think that I would charge it as that. That would mean that somebody's coercing another person to give them photographs. So if this student here was saying, come on, just give me a little shot, send me a picture, what harm will it do? In that type of case, that's your exploitation of a minor type of charge.
Okay, and as a judge, once this case was submitted to the judge for a decision, there are a couple elements at each level that the state needs to approve. The first element is on about a certain day of a certain month of a certain year, the defendant knowingly purchased, possessed a negative, slide, book, magazine, print, or visual medium. The second element is the material shows a person under the age of 18 years engaging in a prohibited sexual act or in the simulation of a prohibited sexual act. If the state proves both of those elements, the court's decision is going to be guilty. And those elements are similar as you go up the ladder in the Class D felony. I was reading off the aggravated misdemeanor. They go up into the Class D felony. They're about the same. When you get to this Class C felony, which is a 10-year sentence, the elements are a little bit different. Basically, the first element, you have to have a certain day, month, and year when the defendant used or persuaded or induced, enticed, coerced, knowingly permitted, caused a person under the age of 18 years to A, engage in a prohibited sexual act or engage in the simulation of a prohibited sexual act, and 2, the defendant knew or had reason to know that the intention of the act would be A, be photographed, B, be filmed, or C, be preserved in a negative, slide, book, magazine, print, or visual medium. If the state meets both of those elements, then the defendant would be found guilty of a Class C felony, which carries a 10-year prison sentence.
Just briefly, I do have something to add to that. There is not a difference between, except for in the level of the felony, between a sexual act being filmed and just nude photos. That's still pornography, whether or not the nude photos are depicting anything sexually suggestive. So you can still be prosecuted even if it's a photo that's not showing any sex act.
Okay, yay for our volunteers, bravery is personal. issue for kids to talk about with their parents, but that kind of means it might be an important issue. Better to talk about it before it becomes a problem for young people rather than after it's already a concern. Similarly to what we did before, and again, I know this is a sensitive subject, and gross, your parents are here, or gross, your kids are here. Does anybody have any questions about how the possession of images or the distribution of images might be dealt with in a legal realm? You've answered every question they have. Amazing. Amazing. Obviously, there are a vast number of issues in addition to concerns about cyberbullying, concerns about possession and distribution of illegal images. We did not write a mock trial about students having additional private accounts that their parents are unaware of, or having anonymous accounts. But this is an issue that I hear about a lot as a teacher. It's also an issue that administrators and parents are starting to hear more about. There is nothing worse than a parent being shown a screenshot and it says, your kid put this on Facebook, and they say, no, I'm friends with my kid on Facebook. Not this account. So I wondered if you wanted to take an opportunity to sort of talk about anonymous accounts, or to talk about, you know, a secondary account as something that might be dangerous, or maybe you have no.
Greg? I'm going to ask Mr. Chase here. He has in his profession dealt with some different ways that the state has to I guess get a hold of or view some of the things on hidden accounts and that type of thing.
Hi there, my name is Greg Chase. I work with the Drug Task Force in Council Bluffs, but I'm also assigned to the FBI's Child Exploitation Task Force, which means when I go to work, I can either buy drugs or people, depending on how I feel that day. I will talk about the investigative part of what goes on here. When it comes to hidden accounts or your devices, that stuff is on there. That stuff is on it forever. Working with the FBI, we have the ability to probe into those phones, tablets, computers. I have a case that just recently came to an end. I have over 500,000 pages of evidence. How I got all those pages? We wrote search warrants. We did subpoenas. Subpoena is a fancy word for a key for me to get into your information through the company. Say you have Verizon. I can subpoena your records through Verizon and find out where you're sending text messages to, where you're sending pictures to. I can do a search warrant for Facebook. Facebook is a great, proactive, law enforcement friendly business. I have personally talked to the head of security for Facebook. If I want something, I get it. And they're great on getting it to you. That stuff doesn't go away. It's all stored. There's a lot of ways out there that people can communicate. You know, different IP addresses. I'm not going to get too technical because I'll get over my head because I'm not a computer person. But we can track down where you're sending that stuff from. If you think you're safe at your house sending this on a random site where you say your name is John Smith, you are not. We can backtrack. We can go to that person. We can go to that kid who went to school and said, hey, some guy sent me a picture of his penis. And here's the name he used, here's his screen name, here's his kick name, Snapchat name, whatever chat you want to use. And we can backtrack and find that stuff. And then I come knocking on your door with a search warrant, and I take everything. Anything that could have a picture, photograph, or a document, I take. At the case where we have all this evidence, we went, searched the house, well over 100 items. Computers, SD cards, thumb drives, cell phones, anything you can store a picture on, I took. I took it to the FBI. We went through it all, and we found over 1,000 images of child pornography, ranging from 17 to 4. That's pretty bad. I found a homemade video where this guy set up a GoPro in his bathroom, had an 11-year-old go in there and take a shower, and he recorded it. I found that little girl. You know, we're out there, we are working. One of the pluses of working with the FBI is that they're all over the country. They're all over the country. They have endless amount of resources. It's a great tool. It's great to do this stuff. So with all these images, you know, we also send this to the National Center of Missing and Exploited Children. Its nickname is NCMEC. It's based out of Virginia. They house all the child pornography images that are discovered by law enforcement. They house them all. What I did in this case, I took all 1,000+ images of child pornography. I sent it to them. They were able to identify 167 of the kids in that group, which means that these kids have been found, they've been rescued. The bad guys can actually be charged civilly, or not charged civilly, sued civilly for restitution for these 167 kids. But the resources are out there. I guess that's my point is,